Good morning to all my dear students. Today we are going to discuss about the drafting of caveat as provided under section 148A of the Code of Civil Procedure. But before going to start with the drafting of caveat, I just want to recapitulate the law relating to caveat. For better understanding of the topic as well as the students would be apprised with the law points to be dealt into while drafting the caveat. So let's start with the concept of caveat as defined or as provided under the Code of Civil Procedure. Meaning thereby, Code of Civil Procedure provides the basis or the law relating to caveat. Hence, we would easily infer that there is a close relationship between the subject of Code of Civil Procedure and drafting, pleading, and convincing. Meaning thereby, the Code of Civil Procedure provides the basis for drafting of caveat. Now let's start with this. My dear students, the term caveat has not been defined in the code. As you all are aware that section 2 of the Code of Civil Procedure 1908 provides or defines certain expressions or concept under section 2 of the Code of Civil Procedure. But the said section has not provided or has not defined the word caveat. Next, what is the literal meaning or the Latin meaning of the word caveat? The Latin meaning of the caveat is to means or which means be aware. As you all are aware that the concept of caveat is also having a similar resemblance under the or the said word caveat has been used under different laws such as Partnership Act. My dear students, as you are aware that section 16 of the Partnership Act defines caveat emptor or the principle of caveat emptor means let the buyer be aware. So from that we may infer that there is a kind of resemblance between the drafting, pleading, and convincing, and also the Code of Civil Procedure, and moreover the Partnership Act, meaning thereby they all are having the close resemblance or interplay between each other. Next, one of the dictionary of English law, which has been written by Earl Joviat. This is 1977, volume number 1, page number 298, defines caveat as caveat is an entry made in the books of the offices of the registry or court to prevent a certain step being taken without proper notice to the person entering the caveat, meaning thereby a caveat is a caution or a warning given by a party to the court not to take any action or grant any relief to the applicant without notice being given to the party lodging the caveat. So from this, we may infer that in this, the caveator demands an opportunity of being heard from the court before deciding any particular issue in any case which is going to be instituted against him by the other party or by a person whom he have threat that he is going to institute a civil suit against him in a court of law. So from this, we may also infer that it also demands the principles of natural justice as defined under the administrative law to be fulfilled before deciding any case against him, or the case which is going to be instituted against the caveator. My dear students, the most common example of caveat we would find in the case of testamentary proceedings. So from this, we may infer that caveat is generally filed in the case of testamentary proceedings, which are provided under the Indian Succession Act or Hindu Succession Act, as the case may be. It is a precautionary measure taken against the grant of probate or letter of administration. Section 148 does not define the word caveat, but it only provides for the lodging of a caveat in a court of law by the caveator. Now, what is the object behind filing the caveat? The underlying object of a caveat is twofold. Firstly, to safeguard the interest of a person against an order that may be passed on an application filed by a party in a suit or proceedings instituted or about to be instituted. Such a person lodging a caveat may not be a necessary party to such application. This section affords an opportunity to such party of being heard before an ex parte order is made against him by the court of law. So from this, my dear students, we may infer that one of the prime objects of the caveat or the filing of the caveat is to provide an opportunity of being heard to the caveator. Next. Secondly, is to avoid multiplicity of proceedings. As you are aware that caveat or the lodging of a caveat is provided under Section 148A of the Code of Civil Procedure. Here A denotes an amendment in the law. So from this, one question may arise that in which year this amendment took place. My dear student, this amendment in the law took place in the year 1976. Now, there is second question which may arise here. That is, what was the position of the caveat before 1976? Before 1976, the aggrieved person who is not a party to the application and is aggrieved by the order passed by this court does not have this remedy. As such, Law Commission recommend to insert this provision in this regard. As such, in 1976, new provision was added. So my dear students, from this we may infer that no such remedy was available to the caveators or to the persons who have the apprehension that a case is going to be instituted against him. They don't have the remedy of an opportunity of being heard from the court of law at the first instance itself. Now, what is the nature and scope of the lodging of a caveat? This was explained by the Supreme Court or by the Apex Court in the case of Ramchandra versus State of Uttar Pradesh, EIR 1966, Supreme Court 1888, wherein the Supreme Court has held that the civil proceedings not only includes the original proceedings, but would be applicable to suit, appeals, as well as other proceedings under this code or under any other enactments. So from this, we may infer that the Section 148A uses the expression civil proceedings. Now, the question which came before this Honorable Supreme Court is that what does the term civil proceedings denote? The Supreme Court, after going into the various provisions and the law on the point, came to the conclusion that the civil proceedings here does not mean only civil proceeding, but also includes civil suits. And it does not only include original proceedings, but also applies to civil suits, appeals, as well as other proceedings under the code. Now, the next question which came to the mind of a law student here is that who may file this caveat? Whether he must necessarily be the party to the case or anybody else also. To this, the law is that not only the party to the case, but also the aggrieved party who has substantial interest in the case, they can be able to file this caveat in the court of law, meaning thereby this not only includes necessary party, but also the proper party as defined under or provided under the Code of Civil Procedure. When can this caveat be filed? My dear students, generally a caveat can be filed after the judgment is pronounced. In exceptional circumstances, a caveat may be filed even before the pronouncement of the judgment. Where caveat does not lie, this is also one of the another important question. It can be attracted only in the cases where the caveator is entitled to be heard before any order is made on the application already filed or proposed to be filed against him in the court of law. Now the second question or the another question which needs to be discussed over here is that is there any format for filing the caveat under the Code of Civil Procedure? But there is no such format provided, but Indian Succession Act, Section 284, Clause 4, Schedule 5 provides the same. Next. So this is all about today's topic. But before parting with the today's lecture, I would like to apprise you with my new topic, which I am going to take in my next class. And the topic is that in my next lecture, I would like to discuss with the rights and duties of the parties to the caveat, that is caveator, applicant, and the court. Meaning thereby, there are three parties to the caveat, and these three parties are caveator, applicant, and the court. Next question is, or the next point which I am going to deal in my next class is, what is the effect of the failure to hear the caveator? Is there any time limit for which this caveat is there in the court of law? And in the last, I will let you know how to draft a caveat application. So this is all about today's lecture. Stay home, stay safe, and stay healthy. Till then, thank you. We'll meet you soon in my next lecture.